afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to give you some updates and provide you some tips regarding adjustment of status in the United States during the time of pandemic. I would like to provide you with some information as to what you need to keep in mind if you are a person who is preparing to file his or her adjustment of status application at this specific time. So first of all, you need to know that adjustment of status package fees are going to go up significantly starting October 2nd, 2020. And it's not the form I-45 or I-130, two very commonly used forms that fees for which are going up. But it's a fact that now, if you're going to be filing for adjustment of status, you will have to pay separately for work permit and for travel permit. Currently, I'm speaking about the time when the rule yet has not changed. If you submit your adjustment of status application, you can add forms for work permit and for travel permit. If you're paying full price for the adjustment of status, you do not have to pay for the work permit and travel permit forms. That's what we have currently. But it's going to change starting October 2nd, 2020. Application for work permit is going to be $550. An application for a travel permit is going to be, I believe, $590. It means that the cost is going to go up significantly. Why? Because most applicants, applicants for adjustment of status, understandably, would like to have a work permit, right? You would like to work in the process while you're waiting for your green card. And now you will have to pay separately for that. Also, if you would like to renew your work permits, you will have to pay separately for that. Meaning that, let's say you filed your application after October 2nd, 2020, you would like to renew your application for work permit if your adjustment of status is pending for longer than a year, you will need to pay. Currently, people who are renewing their work permits after they filed the initial adjustment of status application and paid the full fee for it, they did not have to pay for renewal of those work permits. I mean, they may have to pay to an attorney, but there was no government filing fee to renew their work permits. So that's actually a very significant change for adjustment of status cases. You have to keep it in mind. Public charge. Right now, from July 29th, 2020, you do not need to worry about the new public charge rule because the government stated they will follow the Southern District Federal Court's decision stopping the public charge rule until we have or during the time of the national emergency in the United States. So you don't need to worry about public charge. Last updates that I checked on USCIS website stated that USCIS is not going to take into consideration information on Form I-45 regarding public charge, so you don't need to submit that information. You don't need to submit Form I-944. But you always need to keep in mind that you can file your application, and perhaps what's going to happen is that during the pendency of your application, the national emergency is going to stop to exist. And then the government may ask you to submit those forms and may ask you to provide that information, and you need to be ready for that. Keep that in mind, okay? My advice would be, if you absolutely do not have to, do not use public benefits still. Just because it may be, which I think it will be probably unfair to use against you public benefits that you may use right now, to use them against you in the future, but just to be on the safe side. Of course, there are different situations, and sometimes you have to do what you must. But generally speaking, I think the less public benefits you use, the better for your immigration status if you can safely do so. Okay, do not jeopardize your health or your family members' health and situation well-being just because you're afraid of possible immigration consequences. From what I understand, what's going to happen is that the benefits that you're using now, if you have to use them, they will not be taken into consideration later. That's my understanding, generally speaking. But the rule of thumb, you would like to avoid any possible even thoughts that you somehow can become a public charge, right? You would like to not have this issue. So if you don't have to use them, don't use them. If you have to use them, you have no choice. If it's safer for your family, for you, you do that. And of course, you need to keep in mind that right now, because of the pandemic, the interviews are being scheduled at a very slow pace. Understandably, USCIS cannot see as many people as it did before. It means delays for your case unless the interview is going to be waived. You can expect, probably reasonably expect, that interviews can be waived for work employment related applications, right? Special immigrant juveniles, for example, perhaps even U adjustments, asylum adjustments. Those are the categories of cases that traditionally had their interviews waived. Marriage-based cases, I'm not so sure. I think if it's marriage-based case, filing first time, I think that you will be called for the interview. I've heard one account from another lawyer that stated that he heard somewhere else that someone's marriage-based interview was waived. It may be waived if the person first entered on a fiancé visa, okay? That was the case, that if your fiancé first came into the United States on a fiancé visa, right, and then you guys got married, then there are very good chances that an interview for that particular person may be waived during the adjustment of status. But that's not typical for people who are receiving adjustment of status otherwise, if they did not have fiancé visa before. I personally do not know any accounts of that. They said it's like a hearsay. I've heard from someone that interview was waived. I would not count on that. I would still prepare for the interview. Documents that you need to submit when you file your package, make sure it's well prepared. Make sure you document your relationship very well. Why? Because the policy that your case can be denied without the interview, without the request for more evidence, nobody canceled that policy. That policy is a recent policy relatively, and it says that USCIS does not have to send your request for more evidence. If the case, in their view, lacks evidence, they may just simply deny it. So that's something to keep in mind. So when you file your packages, even if it's a time of pandemic, when it's hard to receive documents, right? It's hard to receive documents. Some places may be closed, limited access. Keep this in mind. You still have to prepare your case very well, especially it is true for marriage-based cases. Well, those are the tips for now. I hope they were helpful for you, and please visit our website www.shautsova.com. I have more information on the website regarding various immigration topics. Like, share, subscribe to my channel. I'm very happy to share any new immigration developments, and I hope to see you soon.